Hi everyone, welcome. I'm Eric Rodabois. This is EPGD Attorneys at Law, and I am filming my second video in my new office. This is technically my first full day here. I've been out of town for the last couple weeks. My team did awesome. They handled the whole move. They handled our monthly billing. They basically kicked ass while I was in California on business and pleasure. So something came up just the other day, and there was like a basic question of what is a trust? All right, so let's talk about that for a second. A trust is an ancient type of entity almost that's created when you put a certain number of ingredients together. So here's the basic ingredients. You need a grantor or a settlor, that's the terminology, and that's the person who's going to give property. Okay, property is the key. Second thing is property. You need property, whether it's money in a bank or land or a business or a house or whatever, okay? Then you need beneficiaries. The beneficiaries are who we're going to take care of. Now, I could set up a trust to take care of myself, so I'm the grantor and I'm the beneficiary, or I can set up a trust to take care of my mother or my family, or I can set up a trust to take care of dogs and cats and wild animals. So you need beneficiaries. Then the fourth thing is you need a trustee, and that's the person who you entrust to take care of the property for the benefit of the beneficiaries. And the last thing, I like to say the fifth thing, is instructions. We usually put that in writing. In fact, I've never really seen a trust that's not in writing. I imagine theoretically in law school we could think of it existing without a writing. But basically it's usually a nice thick document that's going to set forth what the rules are. So here's, for example, I leave $1 million for the benefit of my mother while she's alive for her health, education, support, and maintenance, and I instruct the trustee to manage the property, to make discretionary distributions for her for those four things, health, education, support, and maintenance, and to give her the hire of $5,000 a year or the income that the trust generates. Okay, that's just instructions. And then, upon my mother passing away, I hereby instruct that, and I could say a successor beneficiary. Okay, so we can make these trusts pretty complicated. But here's the basic types of distinctions. We've got inter vivos versus testamentary. So inter vivos means it's trust we set up while we're still alive. A testamentary trust would be one that we set up inside of a will. So when I die, all my property I hereby direct to be held in trust for the benefit of my best friend Jessica, just as an example. Okay. Now, once it's testamentary and once it's in a will, obviously, once I die, then it becomes irrevocable. So that's the other type of distinction. We've got revocable versus irrevocable trust. So a revocable trust is I set it up, and 3 months later I decide that I don't like Jessica anymore, so I revise my trust and I take her out. She's no longer a beneficiary. And then maybe I change it because I like Elizabeth better. But then 3 months later, I decide I don't like Elizabeth anymore and I'm going to make it Stephanie. Okay, you see my point? I can make changes as long as I want. Now, I could also set up an irrevocable trust. I irrevocably say that Jessica is my beneficiary and I can never change my mind. Now, I'm still alive, and that might, be inconvenient at a later point if Jessica and I are no longer friends. And we've actually seen that. Now, if it's in a testamentary capacity or if I'm already dead and the revocable trust becomes irrevocable once I die, then, hopefully I've got more important things to do while I'm traveling around the universe than worry about what Jessica's doing with the trust. All right, and then, the next distinction, and this is really not a legal distinction, is between what we call basic versus special. So I have a list right here that I'm going to read because there's so many different kinds. So we can do charitable trusts, we can do land trusts, gun trusts, Totten trusts, IRA trusts, right? That's for your retirement accounts. We can do irrevocable life insurance trusts. We call those ILITs. Or how about third-party special needs trusts or supplemental needs trusts? Those are the ones that we set up so that somebody doesn't jeopardize their entitlement to government benefits here in the United States. So let's say you have somebody with special needs and they're currently getting Social Security or Medicare, and then what happens is a family member dies and they're about to inherit a bunch of money. Once they get that money, they don't qualify perhaps for a lot of those benefits. Well, if we put the money in a special needs trust, we can do it in a way that they'll still get the benefit of that money. All right. I mentioned the gun trust. How about a qualified income trust, also known as a Miller trust, or a qualified domestic offshore trust, a QDOT? We use those when we have the situation where we want to make sure that the foreign or non-citizen spouses get the benefit of the unlimited marital deduction. We have a credit shelter trust, an intentionally defective grantor trust, a generation skipping trust, a qualified terminable interest trust, also known as a QTIP. a grantor retained annuity trust, or a GRAT, a qualified personal residence trust, or a QPRT, a charitable remainder annuity trust, a CRAT, or a charitable lead annuity trust, a CLAT. And by the way, that's not even talking about all the different things we can do in estate planning that are outside of a will or outside of a trust, such as beneficiary designations on your financial accounts, just as one example. So anyways, there's obviously a deep area of law. That's why we have Elizabeth who specializes in it. And if any of you guys have questions, please give me a call. I'm Eric Rodabois, and thank you.